I think I've met most of you, but not all of you. I'm Lawrence Osgoode and have the great good fortune to be Dean here at Osgoode, which is doubly sweet today since I get to step in for our Associate Dean, Francois Tanguay-Renaud, who's on his way but delayed in traffic, and do a brief introduction for our very special guest, Professor Epiphany Azinge, who is also, for me, a particularly good opportunity for some closing of a circle, because I was welcomed in Abuja by the Institute as their guest a couple of years ago for a chance to speak on some topics of joint interest for Canadian and Nigerian administrative law. Had a chance to see both the caliber of research done by the Institute that Professor Azinge has been the Director General of for the last 5 years, since 2009. And it is a example of a really striking voice of not just law reform and political and economic analysis, but also a place that tries to put in context so many of the important events going on in Nigeria. And as I was saying, that we typically interact with when there's a headline, when there's something that has caught the world's attention, but it's very hard to see what's going on behind it and put it in context. Today's talk, The Proclamation of a State of Emergency in Parts of Nigeria, Problems and Prospects, will link up not just what's going on behind some of those headlines in Nigeria, but connect this up with a broader debate and anxiety throughout the world on states of emergency and martial law, what happens to the rule of law, the role of lawyers, courts, and other legal institutions of accountability in times of crisis. And this is playing out, and I've had the chance to attend some conferences on this in very different parts of the world. And I think the perspective from Nigeria is critically important. So I will not do justice to the full biographic richness of Professor Azinge, but let me just give you some of the highlights. He has a number of degrees and academic stints, including LLM and doctorate from the University of London, and also legal training at the University of Lagos. And his work has mostly been in areas, at least my contact with it, of constitutional, public, and comparative law. But reading deeper, I came across admiralty, shipping law, areas that, let's just say, we don't engage with as deeply as we should here at Osgoode. So he brings a richness also in areas of accountability, election laws, and trying to develop an approach to this notion of oversight and legal accountability that I think is very distinct. We also will have the benefit, I hope, of some of his insights on running the Institute. He's also held administrative positions in different law schools, including a stint as assistant dean at the University of Benin, and also on their Senate. So anyone who's devoted a substantial amount of time to academic administration is a hero in my books, and I look forward to hearing again some of the insights that Professor Azinge will share on that front. The last thing I wanted to note is his work also on the governmental side. He has served as special assistant to the Attorney General and also the Minister of Justice. He served in the 1990s. And has also worked in advocacy and legal settings, particularly as a member of the team before the International Court of Justice in the Cameroon and Nigeria case. So, as usual, we're not just here in this room because we've got a great speaker, but because of the role played by the Nathanson Center, which brings together not just members of our own community, students, and members of York's broader academic community, academics and professors here, but also the interdisciplinary subjects covered by the Nathanson Center on transnational human rights, crime, and security, all are engaged in today's topic. So it's a perfect fit for the Nathanson Center. It's a great opportunity for Osgoode, and it's a personal pleasure to welcome Professor Azinge, having been the recipient of the Institute's hospitality in Nigeria. With that, please join me in welcoming Professor Azinge to the podium.
Distinguished ladies and gentlemen, I feel greatly honored for the opportunity given to me to deliver the 2014 Distinguished Service Lecture of the Jack and May Nathanson Center on Transnational Human Rights, Crime, and Society. I follow in the footsteps of Justice Dalve Bandari of the International Court of Justice and other very distinguished personalities who have spoken on the platform provided by this great center. Well, I've been privileged to read through the mandate of the Nathanson Center, and I note its focus as follows: the development and facilitation of a cross-disciplinary program of research and project initiatives that enhance knowledge of issues related to a variety of transnational phenomena that are now and for the foreseeable future rapidly changing and challenging society, law, and governance. By focusing on three thematic pillars, human rights, crime, and security, the center seeks to harness the critical mass of talent and energy found at the Osgoode Hall Law School and York University more generally, alongside a network of center associates from universities around the world and from non-university sectors. The center seeks as much as possible to make its contribution by studying, seeking to understand, and constantly querying the relationships between crime, security, and human rights, as informed by transnational perspective. This relational and triangulated approach is intended to produce fresh analysis, attendant to the multiple dimensions, the criminal justice, the security, and the human rights angle of a variety of transnational phenomena. Before I settle on the topic of my lecture, let me say clearly that I prepared an earlier version on the title, Administration of Justice in Nigeria, Challenges and Prospects. However, after a careful consideration of the mandate of the center, I decided on a change of course to write on the proclamation of state of emergency in Nigeria, dwelling on problems and prospects. It is my belief that this topic is more in line with the mandate of the Nathanson Center. Two other reasons have informed my choice of the topic. First, Nigeria is undergoing one of the worst challenges to her national security, and this has resulted in the declaration of state of emergency in some states in the northern part of the country by President Goodluck Jonathan, the President and Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. Secondly, that in 2013, my institute, the Nigerian Institute of Advanced Legal Studies, spearheaded a book project on state of emergency in Nigeria, the law and politics. And thirdly, a number of political and human rights questions have bedeviled the exercise of emergency powers in Nigeria since the First Republic, dating back to 1960, thereabout, when it was first deployed by the state. With this background in mind, it is my thinking that the focus of the paper touches on the three thematic pillars of the Nathanson Center, that is, human rights, crime, and security. I shall proceed at once to the substance of my lecture. And I started with a quotation created to Twining to the effect that the problems of public order in an emergency pose agonizing choices and stir deep passion. The subject is topical and urgent, for it raises basic questions about any society's response to dissent and violence. For some time now, the peace, security, and stability of the Federal Republic of Nigeria has come under very severe attack by disruptive forces, waging relentless war against institutions of state, foreign bodies. I'm sure that over a period of time you must have heard about the insurrections and the activities of insurgency groups like Boko Haram, for instance, and their bombing of very, very critical and strategic buildings in Nigeria, including the United Nations building, amongst others. Of course, religious institutions and places of worship, social institutions and commercial centers, amongst others. Doomsday predictions have suggested that at the rate Nigeria is going, she's likely to break up soon. Some say 2015, and we've always answered, may God forbid that. It is certain that the growing insecurity and disruptions to peace and stability in the country have contributed in no small measure to the very negative perception of the future prospects of Nigeria as a state. The 1999 Constitution of the Federal Republic of Nigeria, as amended, which is the ground norm of the country and the basic order that controls and regulates the country, like other constitutions elsewhere, contemplates where peace, security, and stability of the country is threatened. In responding to such threats, the Constitution provides for the exercise of emergency powers by the President or state governors. The circumstances in which emergency powers can be exercised, the manner of its exercise, and the duration of emergency powers are clearly spelled out under the Constitution. Consequently, the expectation is that given the extent of textual clarity of the Nigeria's constitutional regime on the exercise of emergency powers, there should be no tension surrounding the proclamation of a state of emergency in any part of the country where the need for such arises. How much of this expectation is a reflection of reality we will come to discuss in the course of this conversation. What is the promise for the future of Nigeria in terms of the exercise of emergency powers vis-a-vis the peace and stability of this country, of our country, Nigeria? This paper devotes essentially to these core issues. The paper, in addition, will examine Nigeria's experience with the exercise of emergency powers as the constraints of space and time would permit, and arising from that discussion, touch on the problems and prospects of the use of emergency powers in the country. In order to offer a rounded and meaningful analysis of the issues arising in the paper, the following sub-themes will be explored. Firstly, the nature and essence of state of emergency, the history of state of emergency in the country, the regime in the exercise of emergency powers under the 1999 Constitution as amended, followed by the proclamation of state of emergency in Nigeria, a contextual analysis, and then we'll look at problems affecting the exercise of emergency powers in Nigeria and the prospects of emergency powers in Nigeria. Well, we looked at the nature and essence of state of emergency. Generally, we looked at the issues identified by Alexander Hilton, wherein he stated that it is impossible to foresee or to define the extent or variety of national exigencies. The circumstances that endanger the safety of nations are infinite. In other words, he posited that it would be difficult to have a clear-cut definition of emergency in any jurisdiction. Well, I said that notwithstanding this difficulty, various attempts have been made at defining the state of emergency by some state and international statutory instruments. I believe it is important that I make reference to the Emergency Act of 1985 of Canada. Herein, the Emergency Act distinguishes between 4 types of emergencies. Firstly, the public welfare emergency. Secondly, the public order emergency. And thirdly, the international emergency. And fourthly, the war emergency. The Act, the Canadian Act, goes on to define each type of emergency. For example, a public order emergency is defined as an emergency that arises from threats to the security of Canada and is so serious as to be a national emergency. And a war emergency is defined as war or other armed conflict, real or imminent, involving Canada or any of its allies that is so serious as to be a national emergency. In the international arena, the definition offered by the United Nations International Covenant on Civil and Political Rights, We define public emergencies as situations that threaten the life of the nation is also very instructive. The UN Human Rights Committee has characterized states of emergency as times of exceptional and temporary nature. The Syracuse Principles on the Limitation and Derogation provisions define a state of emergency as a situation of exceptional and actual or imminent danger which threatens the life of the nation, and so on and so forth. In Nigeria, the 1999 Constitution does not define state of emergency. It only provides for situations where a state of emergency would have been deemed to have arisen. And it's important that we bear that in mind, that no clear-cut definition in the Constitution or any other laws whatsoever, unlike that of the Canadian Emergency Act. For the purpose of this paper, I will settle for anything that threatens the peace and security of a state, that undermines the territorial integrity of the state, results in the loss of lives and property in the state, disrupts the day-to-day engagements of citizens in the state, or makes it necessary for extraordinary measures to be taken by authorities in the state to arrest an unpleasant situation as the meaning of state of emergency within the context of the 1999 Constitution. With this broad view in mind, I will next briefly examine the essence of the state of emergency. In the context of state of emergency, when we speak of its essence, we should be understood to be talking about its basic or core idea. In a manner of speaking, why proclaim state of emergency? Or what is the rationale for proclamation of state of emergency? Here, there are so many theories that seem to flourish. Well, I don't think that I should make reference to a good number of them. Philosophers like John Locke, Rousseau, amongst others, seem to have made their views very, very clearly known. And the major issue is the trust of the theory of emergence that is predicated on the maxim salus populis suprema lex, which literally means that the welfare of the people is the supreme law. So to that extent, it's generally believed that the theory of emergency is predicated on the fact that the national security, peace, and good governance is very, very critical for the survival of any democracy, and to that extent, it's critical that that should be taken into consideration by the president or any other authority that is responsible in ensuring that the Constitution, as the supreme law of the country, is upheld at any point in time where there is threat to the peace and national security of a country. And I've also made reference to some of the theories that seem to flourish, the absolutist theory, the relativist theory, and the liberalist theory. For want of time, I may not want to dwell essentially on them, but permit me to say that there are some shortcomings as far as most of the theories are concerned. And for instance, the liberal paradigm was the inevitable conflict arising from executive action during emergencies. Executive officials who departed from legal norms in times of war or emergency could be liable for damages to individuals who suffered injury due to their actions. Courts could sanction executive officials who violated the law, irrespective of the necessity for the action. Well, this dilemma thrown up by the liberal construct was vividly captured by President Thomas Jefferson of the United States of America when he wrote, and I quote, "A strict observance of written law is doubtless one of the high duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger, of higher obligation. To lose our country by a scrupulous adherence to written law would be to lose the law itself, with life, liberty, property, and all those who are enjoying them with us, thus absurdly sacrificing the end to the means. The officer who is called upon to act on this superior ground does indeed risk himself on the justice of the controlling powers of the Constitution, and his station makes it his duty to incur that risk. The line of discrimination between cases may be difficult, but the good officer is bound to draw it at his own peril and throw himself on the justice of this country and the rectitude of the motives." Well, I move on quickly to the history of state of emergency in Nigeria. Nigeria became a colony in 1961, following the annexation of Lagos. And of course, The amalgamation of the Southern and Northern Protectorate took effect from 1914. And then, of course, the first emergency law for Nigeria came up via the 1939 proclamation by the British government, the Emergency Powers Defense Act 1939, which was extended to the colonies, and Nigeria also became a beneficiary. That particular legislation was in place in Nigeria up till independence in 1960, and then by the independence constitution was also incorporated as part and parcel of the Nigerian law up to 1964, when the first crisis came in place and required the proclamation of the state of emergency in Nigeria. Well, the provision is contained in section 65(3) of the 1960 Constitution, and clearly replicated what exactly we still have in the 1999 Constitution, that emergency powers can be proclaimed when the country is at war. Secondly, when there is in force a resolution passed by each House of Parliament declaring that a state of emergency exists. There is also in force a resolution of each House of Parliament supported by votes of not less than 2/3 of all members of the House, declaring that democratic institutions are threatened by subversion. The provisions of this section was tested in Western region in 1962, and this followed the rift in the Action Group, the party that had majority in the Western region, and that led to a lot of crisis, and that also led to the end of the First Republic in Nigeria. Well, following the controversy generated by the blanket powers granted to Parliament by the 1960 and 63 constitutions to declare a state of emergency in the Federation of Nigeria or any part thereof where certain conditions are fulfilled, the first democratic Constitution of 1979 that ushered in a presidential system of government in Nigeria adopted a fairly different approach in the creation and exercise of emergency powers. Whilst the two previous constitutions, that is the 60 and 63 constitutions, adopted a parliamentary system of government, the 79 constitution, as already alluded to, went for the presidential system of government. Herein, the proclamation of state of emergency was made the exclusive prerogative of the President and Commander-in-Chief of the Armed Forces, and the conditions precedent thereto was satisfied. The provision is retained under the 1999 Constitution in section 305 thereof, and the prevailing constitutional approach to the exercise of emergency powers in Nigeria clearly spelled out. Well, what do we have in the 1999 Constitution that is fairly different from 60, 63, and 79? As already stated, section 305 of the 1999 Constitution stated as follows. Well, the President shall have power to issue a proclamation of state of emergency when we are at war. Then the Federation is in imminent danger of invasion or involvement in a state of war, which was not contained in any earlier constitution. There is actual breakdown of public order and public safety in the Federation or any part thereof, to such extent as to require extraordinary measures to avert such danger, was also not contained in any earlier one. There is clear and present danger of an actual breakdown of public order and public safety in any federation or any part thereof, requiring extraordinary measures to avert such danger. There is occurrence of imminent danger or occurrence of any disaster or natural calamity affecting the community or a section of the community in the federation. There is any other public danger which clearly constitutes a threat to the existence of the federation, or the President receives a request to do so in accordance with the provisions of subsection 4 of this section. That is section 305. Clearly, we see that we have a much more exhaustive provision under section 305, and the circumstances under which the President can proclaim a state of emergency are already as articulated. Like I earlier pointed out, we have a much more comprehensive in the sense that wider in scope and textual clarity as far as this is concerned vis-a-vis what obtained earlier. And bear in mind to a very large extent, being that we adopted a presidential system of government, it became imperative that Nigeria needed to look towards a presidential democracy that has been in practice for a very long time, and you can as well agree that most of what we have incorporated in the 1999 Constitution as far as proclamation of state of emergency is concerned is exactly what obtains in the American Constitution. What is immediately apparent? In the specification of the conditions giving rise to the proclamation of state of emergency under 1999 constitutional amendment is that the Constitution goes to great lengths to contemplate the series of misadventures that may necessitate the interruption of the normal functioning of government under law in a democratic setup of Nigeria. It is argued that the wordings of Section 305(1) of the Constitution, which states that the President may proclaim a state of emergency, where these conditions are present, imply a discretion on the part of President to also refrain from proclaiming a state of emergency and adopt other means for bringing about an end to the challenge being posed to public order, peace, and security of the nation. When we compare Section 305(3) of the Constitution as amended with Section 65(3) of the 1960 and 1963 Constitutions, respectively, it is easy to appreciate the marked difference between them. First, unlike the 1960-63 Constitutions, where all that was required for a state of emergency to come in effect was entirely a resolution by Parliament that such a state of emergency exists in the Federation or any part thereof, under the 1999 Constitution, the circumstances giving rise to a proclamation of a state of emergency have been carefully enumerated to avoid any dispute as to whether there is indeed an emergency. The logic to this approach can be appreciated when one recalls the crisis that followed the proclamation of state of emergency in the Western region by the federal parliament. So what we were able to achieve through the 1999 Constitution was obviously to avoid all the mistakes of 1960 and 63 that created the crisis in the Western region and led to the collapse of the First Republic of Nigeria. Whether we've been able to achieve that in reality will also form part of the discussion today. Another major difference between the provisions on emergency power under 1960 and vis-a-vis the 1999 Constitution is that whereas under the former emergency powers, whereas under the former emergency powers were those of Parliament to exercise, under the 1999 Constitution, the presidential system of government being practiced has meant that discretion whether or not to proclaim a state of emergency is solely that of Mr. President. A third difference is that under the 1999 Constitution, state governors are given an opportunity to determine whether a disruptive situation in their domain is one that necessitates a proclamation of state of emergency. Where any governor is of the opinion, the Constitution provides for the procedure to be observed by the governor to secure the proclamation of state of emergency in the state by the president. It is pertinent to note that the power of the governor to invite the president to proclaim a state of emergency in the state is not one that can be overlooked by the president. The president can only proclaim a state of emergency in a state where the governor of the state had failed within a reasonable time to invite the president to make such a proclamation where the conditions necessitating such a proclamation abound. What are we saying here? All we are saying is that, yes, Nigeria is a federation and powers of the executive are shared between the president and the governors. But as far as Section 305 is concerned, only the president can proclaim a state of emergency. The governor cannot. But the governor can, if the circumstances arise, point out to Mr. President the need for state of emergency to be proclaimed in a particular state, especially the state of the governor. But like here, we are arguing that the president can overlook such an invitation to proclaim when all the information available to the president is such that the situation has not arisen. Or the president can also, believing that the governor has not within a reasonable time drawn his attention to so proclaim, go ahead without the invitation of the governor also to proclaim. To that extent, it means that the governor is not a chief executive properly so called within the context of presidential system of government, and to that extent has a whittled down power and creates a situation where the overriding power rests with the president and the president only. What shortcoming of the extant regime on the proclamation of state of emergency as contained in the 1999 Constitution, which does not reflect an improvement on the position under earlier Constitution, is a failure of the 1999 Constitution to specify the procedure after a proclamation of state of emergency has been made. Would it result in the suspension of the democratic institutions and the installation of a new government structure by the president? Or is the emergency measure merely conferring greater executive discretion on the president or state governors to the extent that the president or state governors, as the case may be, can adopt measures and deploy the resources of the federation or state in a manner that, but for the proclamation of state of emergency, would have required legislative approval? Well, what the argument here is that we went through this process in the First Republic from 1960 to 1964-65. We went through this process when the state of emergency was declared in the Western region in the 60s. What the Prime Minister did at that point in time was clearly to shut down the democratic institutions and invite some outsiders to take over the reins of government. So that worked and flourished effectively and created the crisis, like I said, that led to the collapse of the First Republic. Now, as it is, we have noticed between 2006 and 2014 that we have had some conflicting ideas about what to do with democratic institutions whenever there is a breakdown of law and order to the extent that the president will declare a state of emergency. In 2006, we are all aware that President Obasanjo not only proclaimed a state of emergency, but also went on to obviously dismantle all the democratic institutions. And that happened in Ekiti. It also happened in Plateau. But now we have state of emergency still ongoing in 3 states of the country. We have state of emergency in Borno, in Yobe, and Adamawa, but the democratic institutions are still on, under the same constitution, 1999 constitution. So things keep shifting depending on who is in power and depending on the understanding of who is the president of the Federal Republic of Nigeria, as the case may be. But my opinion on this will be clearly spelled out as we progress in this discourse. It is argued that the failure to clearly specify what the procedure should be after a state of emergency has been proclaimed was one of the major shortcomings of the 1960 Constitution on the utilization of emergency powers. Under the 1999 Constitution, we witnessed a repeat of that shortcoming, especially in the administration of President Olusegun Obasanjo. The procedure for proclamation of state of emergency in Nigeria. We've already mentioned that. But going forward, we say that the section provides as follows. Under subsection 2, that subject to the provisions of the Constitution, the President may by instrument published in the official Gazette of Government of the Federation issue a proclamation of state of emergency in the Federation or any part thereof. The President thereafter shall, after the publication, transmit copies of the official Gazette of the Government of the Federation containing the proclamation, including the details of the emergency, to the President of the Speaker of the Senate and the Speaker of the House of Representatives, each of whom shall forthwith convene or arrange for a meeting of the House, of which is a President or Speaker, as the case may be, and consider the situation and decide whether or not to pass a resolution approving the proclamation. Well, it is important that we put this in proper perspective, that within the context of separation of powers as is present in our Constitution, that the President in isolation cannot proclaim a state of emergency. The President agrees that there is need to proclaim a state of emergency, and this is obviously done through the instrument of official Gazette of Government, which the President now transmits to the National Assembly, and both arms of the National Assembly for that matter. Firstly, to the President of the Senate, as far as the Senate is concerned, and next to the Speaker of the House of Representatives. After which there should be a resolution of at least 2/3 of both houses supporting that the approval for the proclamation of emergency. I believe this is instructive because within the ambit of separation of power and the theories of checks and balances, as the case may be, it is a clever way of ensuring that an unwieldy president and a dictatorial president, for that matter, cannot use that as a vehicle for victimization of places or states wherein he may feel that politically his interest may likely be jeopardized. So to that extent, it is important that we appreciate that the president per se, even though the final right rests with him to proclaim a state of emergency, he cannot do so in isolation. The procedure listed out is quite instructive and is very clear that he must do so together with the President of the Senate and the Speaker of the House of Representatives, indeed the whole National Assembly, because he will require ordinarily two-thirds majority of both houses approving that such a proclamation should come to force. The point has previously been made that under the 1999 Constitution, the decision whether or not to proclaim a state of emergency must initiate from the executive arm, whether at the federal or state level. The National Assembly or State Assembly cannot initiate the process on their own or compel the president to make a proclamation by a resolution passed by them. The powers of the legislature with respect to proclamation of state of emergency will only arise after a proclamation has been made by the president and copies of the official gazette transmitted to the National Assembly. The import of this procedural measure by the Constitution is to reinforce the separation of power. I think we have said that. It is also important to note that the provisions of subsection 4 of the Constitution, which vests on state governors the discretionary power to seek a resolution of the State House of Assembly, enabling the governor to request the president to issue a proclamation of state of emergency, is also one that we cannot lose sight of. What are we saying here? What we are saying, in effect, is that even the governor, where the need arises and the governor feels that there is need to inform the president that the situation has arisen for a state of emergency to be declared in a particular state, the governor on his own, so much cannot invite the president so to do. The governor must also seek the approval of the State Assembly. And having received the approval of the State Assembly, he will now be in a sound footing to further invite Mr. President to make a proclamation of state of emergency in that particular state. And upon inviting Mr. President, the next action will be for the President to go through the process of making sure that he receives also the approval of the National Assembly. So whichever way, the states of the Federation and the National Assembly, through the direct representative of the people, as is the case in the National Assembly, will always have a role to play in the determination of whether a proclamation of state of emergency should be made or not. I now move on to talk about the powers of the president. Well, we've already addressed the power of the president to make such proclamations. I've also addressed the power of the National Assembly, as the case may be. And then, of course, we have also addressed the powers of state governors in a state of emergency and the State Assembly. Well, in a constitutional situation, state governors in Nigeria have no powers of their own to declare state of emergency. We have addressed that. But if we consider the situation in the United States of America, I believe that the literature is a little bit different. Under the United States system, the primary source of executive emergency power is the state constitution. Those states often codify the constitutional executive emergency authority or occasionally delegate additional legislative powers to the governor. The provisions of state constitutions from which executive emergency powers are derived display a marked uniformity. Every state constitution confers the executive power upon a governor or designate the governor as the chief executive officer of the state. Every state constitution also designates the governor as commander-in-chief of the state military forces. I believe, again, it is important that we draw this line of distinction, that the states in Nigeria do not have constitutions. They don't. Under the First Republic, yes, the regions operated their own independent constitution, but under the present dispensation, states do not have their constitution. And to that extent, the whole idea that Nigeria is not practicing the true federalism that we propose to practice is very, very instructive for us to bear in mind. So unlike the American situation where the state's constitution empowers the state governors to proclaim state of emergency, there is no constitution in Nigeria for the states, and to that extent, there is nothing to authorize the state governor to proceed to proclaim a state of emergency. Now, the powers of the State Assembly, the powers of the State Assembly in a state of emergency is provided by Section 3054 of the Constitution. The power provision empowers any state House of Assembly to pass a resolution supported by 2/3 of its members, authorizing the state governor to request the president. The specified conditions are those contained in subsection 3C and D of the Constitution relating to the actual breakdown of public order or safety, requiring extraordinary measures to restore peace and security. Where there is a clear and present danger of a breakdown in public order and safety requiring extraordinary measures, or where there is an occurrence of imminent danger. Well, constitutionalists will always try to look at some of these clear-cut constitutional provisions. When is there an actual breakdown of public order or safety requiring extraordinary measures, where do you believe that there is a clear and present danger of a breakdown in public order and safety, and there is an occurrence or imminent danger? Well, the lot of literature seems to have flowed from Nigeria within this shorter time, but generally reliance is based on the American constitutional literature, and a lot seem to have been derived from when one can say that there is actual breakdown of public order or where there is a clear and present danger. The whole clear and present danger theory and doctrine is clear and well known to constitutionalists all over the world. Well, the duration of proclamation of state of emergency. In the absence of any revocation or elongation or proclamation of state of emergency, the duration usually is 6 months. In other words, it is revisited after a period of 6 months. So when a proclamation is made, maybe in March, 6 months after, it must be revisited, no matter the enormity of what is before the country as far as national security, peace is concerned, in the sense that failure to do so will mean that the proclamation will run in perpetuity. And to allow the president to run away with that is to allow the president to have an unbridled right to determine what goes on. And the president on his own can also not determine when the 6 months should be revisited or not, because the procedure is that he must go back to the National Assembly, and the National Assembly, through a resolution, will also empower him to now either add additional 6 months or to end the whole process, as the case may be. The 6 months duration can be extended. It can also be abridged, as the case may be. If the first 6 months is proclaimed, and within 2 months, there is need to believe that the situation has obviously died away, then the president can obviously call off the state of emergency even before the expiration of 6 months. But where after 6 months it is evident that the situation has not abated in any form, the president, with the consultation and the support of the National Assembly, can go ahead and extend that process. How many times it can be extended is not in any way indicated, but the position clearly is that it can be extended as many times as possible, considering the state of situation in the country at that point in time. The proclamation of state of emergency, I want to now look at the contextual analysis. What happened in Western region in 1962, who was right, who was wrong, and then what happened more importantly in 2006. But before then, I've tried to look at some other issues that are tangentially relevant for this center, because the issue of human rights and national security, that is the platform of this center, cannot be glossed over. So to that extent, I've tried to build into this paper the implications of the use of emergency powers in 1962 for human rights and constitutionalism. The implications of emergency rule for human rights and constitutionalism in the Western region in 1962 can be assessed against the backdrop of 3 cases which were brought against the administrator of Western region by Chief Rotimi Williams, senior advocate of Nigeria, who in his lifetime was a leading legal luminary in the country. The 3 cases bear the same title and are distinguished by numbers. Number 1, in the matter of the Emergency Powers Jurisdiction Act 1962, and in the matter of an intended action, FRA Williams against Dr. Efe Majekudumi. Now, number one, here the plaintiff was restricted from movement within the geographical location of Western Region just because they felt that he was a threat to government at that point in time, and the matter went to court trying to argue restriction from movement, and that is a curtailment of his fundamental human rights, and to that extent should be obviously thrown aside. I think the court granted this order. Again, in the same case in 1962, the issue for determination was whether the restriction of the movement of the applicant under the emergency regulation is one that is justifiable in a democratic society. Again, here the applicant, Rotimi Williams, was also held by the courts to obviously be within his powers to contest the issue, and to that extent, the matter was also ruled in his favor. And so also was the third case, also by the Rotimi Williams. So generally, the position as far as human rights is concerned is that very early in the day, as far back as 1960, the Nigerian courts have placed themselves in a position where certainly they can rule where there is a violation of human rights, even under emergency situations. To that extent, the court has not obviously abdicated their responsibility in that regard, and to that extent is a clear statement to the extent that the proclamation of state of emergency is not an invitation for anarchy or for the military to run riot, as the case may be, and do whatever pleases them. Now, I also looked at the implication for crime and security, again, against the background of the center's thematic position. And I say that the political crisis that rocked the Western Region Parliament were severe. It was largely restricted to political circles. Law and order in the general population of Western Region continued to be maintained by the police. This was the major argument raised by the political class. Reference was also made to earlier riots in northern Nigeria, which did not lead to a proclamation of state of emergency. Now, the position as regards crime and security, the crisis was within the parliament. It was never at any point in time extended to the civil populace. So the question was that there was a question of riot in the northern region and in the eastern region earlier than that which occurred in western region. Why did the Prime Minister and his wisdom not proclaim a state of emergency? Now, this politicization of proclamation of state of emergency was an issue, obviously, that affected the survival of the First Republic, because from very early in the day, people started having this notion that, yes, the proclamation of state of emergency can become a political weapon to be utilized by the authority, as the case may be, Prime Minister or President, at any point in time to hack down perceived political enemies, as the case may be. Now we move on to the utilization of emergency powers in Plateau and Ekiti State. These are more recent, 2003 and 4 and 2006 by President Obasanjo. Well, in May 18, 2004, Obasanjo proclaimed a state of emergency in Plateau. His basis for so doing was because of the sectarian crisis in 3 communities in the state, in Langtang, Wase, and Yelwa Shandem. In justifying the measures, the president observed, and I quote, "Tension and social differences have been exacerbated, rather than building new bridges of harmony, tolerance, inclusion, and accommodation. Political errors have been magnified and politicized by opportunistic politicians that often put personal interest above those of the people and the state. Violence has reached unprecedented levels, and hundreds have been killed, with much more wounded or displaced from their homes on account of their ethnic or religious identification. Schooling for children has been disrupted and interrupted. Businesses have lost billions of naira and property worth much more destroyed. Christians and Muslims that used to live together have become arch enemies, and the embers of hate have reached totally unacceptable levels." End of quote. Consequent upon the proclamation, President Obasanjo suspended the state governor and his deputy, as well as the Plateau State of House of Assembly. In other words, all democratic institutions were suspended. The suspensions were for 6 months in the first instance. Retired General Chris Ali was appointed the sole administrator to take charge of the affairs of the state during the period of emergency. A lot of controversies were generated by the actions of the president, which eventually resulted in an action before the Supreme Court in Plateau State of Nigeria against the Attorney General of the Federation and another. Unfortunately, the action before the Supreme Court, which was filed by no other than the leading constitutionalist in Nigeria, Professor Nwabweze, was decided on a preliminary objection filed by the federal government, effectively denying Nigeria's jurisprudence the benefit of a pronouncement by the Apex Court on some of the constitutional questions that were raised in the suit. It is to the legal community that we must thus rely for an analysis of the human rights, constitutional, and other implications of the state of emergency, which was proclaimed in Plateau State in 2004 by President Obasanjo. On the 19th of October 2006, President Obasanjo again, for the second time in his administration, proclaimed state of emergency in Ekiti State. His basis for so doing was because of the political crisis in the state where State Governor Ayo Fayose had been impeached alongside his deputy, and a power struggle ensued between the impeached state governor, the deputy governor, and the Speaker of the House of Assembly, where each lay claim to being the governor of a state. In other words, at a point in time, there were 3 governors, or perceived governors of the state. A flurry of judicial impropriety resulting in the unconstitutional suspension of the chief judge of the state and the appointment of an acting chief judge by the State of Assembly complicated the picture even further. Now we now have a situation, we don't know who the governor is. To worsen the situation, the chief judge was suspended, acting chief judge appointed, so we don't even know who the chief judge is. And to that extent, you bear in mind that the House of Assembly was also suspended. In other words, both the executive, legislature, and the judiciary were all compromised as far as the situation was concerned. Now, President Obasanjo, in proclaiming a state of emergency, observed as follows: the governor and his deputy, and those who are purported to be acting governors or deputy, by this declaration will all cease to be in charge of the affairs of Ekiti State. An administrator to manage the affairs of Ekiti State in the person of Brigadier General Tunji Olorin is hereby nominated for 6 months in the first instance. The Ekiti State House of Assembly also goes on suspension as the former legislative body of the state with immediate effect for 6 months. Having a state House of Assembly in position under state of emergency is incongruous. That is President Obasanjo. Whether constitutionally right or not is a totally different proposition. But that is Obasanjo saying that the situation is incongruous and may not allow for the expeditious actions that the administrator will need to put the state back into a situation of peace, harmony, security for all, and maintenance of law and order throughout the state. Elected officials below the state level are not suspended. The Federal Gazette containing the declaration was forwarded to the National Assembly in accordance with the provisions of Section 305(3). Implications of the state of emergency in Plateau for human rights and constitutionalism. The human rights questions in 1962 did not reoccur in 2004 and 2006 respectively, when a state of emergency was proclaimed in Plateau and Ekiti states. However, the questions that arose were of a constitutional nature and involved the following. Firstly, what is the constitutionality of the proclamation of a state of emergency over the whole of Plateau and Ekiti states by the president, given the largely localized nature of the crisis that gave rise to the proclamation of state of emergency? B, what is the constitutionality of the suspension of the democratic structures in Plateau and Ekiti states, namely the state governors and state houses of assembly, respectively? And lastly, what is the constitutionality of the emergency regulations sent to the National Assembly by President Obasanjo for approval? Let me explain this better. As clearly stated, we had crises in Shandam, Yelwa, Shandam, Wase, and Langtang local government. In a particular local state, Plateau, for instance, I think there are about 24 local governments in Plateau. So you have only three local governments affected by crisis. And based on that, you now declare state of emergency in the whole state. Well, going by what is obtaining in Adamawa and some other parts of Yobe and Borno to an extent, I believe that it would appear that we have moved on and in the right direction, because for Ekiti, there was no problem apart from the key actors. the key actors, meaning the governor and the deputy governor, in a tussle for power and control. Whether that, again, is sufficient on its own to warrant a proclamation of state of emergency is one that we will also address in the course of this conversation. Well, on the first question, the legal community in Nigeria appears unable to come to an agreement as to whether the proclamation of state of emergency in the whole of Plateau State was proper, having regard to the fact that the factual circumstances that gave rise to the proclamation was largely localized to specific areas of the state. Professor Nwabweze argues, for instance, that the declaration of state of emergency in Plateau should have been limited to the crisis areas. In his view, it is not a requirement of the Constitution, 1999 Constitution, that a breakdown of public order must occur in all local governments of a state before a state of emergency can be declared. There are so many other scholars that have also share the same position as Nwabweze, in that Obasanjo was wrong in following the process of proclaiming state of emergency in the whole of Plateau State and Ekiti State, respectively. Now, with respect to the second question, there's a great deal of unanimity in the legal community that President Obasanjo also acted or traversed his constitutional powers when he suspended the democratic structures in Plateau and Ekiti states. I don't need to dwell on this because I also share this view that it is out of place, it is also unconstitutional, indeed almost irresponsible, that you have to dismantle democratic institutions and structures just because you have proclaimed a state of emergency. I believe that we have learned the right way, and we're happy that President Jonathan has not replicated that process, even operating under the same constitution. Now we take it that there are a few clear, well-stated conditions that a governor can be removed, either death, impeachment, as the case may be. Nowhere in the 1999 Constitution is it stated that another way that a governor can be removed is through a proclamation of state of emergency. To that extent, it is clearly unconstitutional for President Obasanjo to have dismantled the democratic structures. One will appreciate the profundity of the unconstitutionality of President Obasanjo's reason for deposing the democratic structures, particularly the State House of Assembly of Ekiti State, when a careful consideration is made of a view he expressed in the speech he gave justifying why he had to suspend the State House of Assembly in Ekiti State. According to Obasanjo, quote, having a state assembly in position under a state of emergency is incongruous. We have repeated that. This simple statement sums up the extent of President Obasanjo's misunderstanding of the nature of state of emergency and the limits of his powers under the Constitution. With respect to the third question, whether the 1961 Act enabled the Governor General and Council to make such regulations as appear to him to be necessary expedient for purposes of maintaining peace, order, and good government in Nigeria, any part thereof, and such regulation, then the question was clearly answered by so many other scholars who felt that the situation in 1961 was quite different from the situation under 2004 and 2006 respectively, because hitherto we operated a parliamentary system of government under the headship of the Prime Minister, and now the President exercises executive powers, and to that extent clearly is the chief executive as far as government is concerned. Well, the 1961 Emergency Act is no longer part of the laws of the Federation because it was omitted in the laws of the Federation 1990. In addition, all regulations made under it lapsed by a fluxion of time under Section 65(2) of the 1960 Constitution, providing that any provision of law enacted in pursuance of this section shall have effect only during a period of emergency. By implications, the Powers General Regulations 1962, which authorized appointment of an administrator, lapsed with the affliction of the emergency in Western region. In other words, the argument is that even if the Constitution is silent on the issue of suspension of democratic structures, could it have been possible that we can smuggle it in through the Emergency Regulation Act 1962? The answer is in the negative, because that particular regulation lapsed with time and was in no way incorporated into other laws that are extant in Nigeria at this point in time. To that extent, again, through the back door, Obasanjo was wrong because there was nothing to support the position that Obasanjo took. Mwabweze argues that supposing the Emergency Powers Act 1961 and the Powers General Regulations 1962 to be existing laws, they are also inconsistent with Section 11(4) and 5 respectively of the Constitution as amended, and that Sections 305 of the 1999 Constitution gives the federal government no emergency powers, legislative or executive, exercisable during a state of emergency, unlike the position under the 1960 Constitution. Well, implications of state of emergency proclamation in Plateau and Ekiti states for crime and security. In Ekiti, there was no violent conflict resulting in the loss of lives and property. What motivated the president to proclaim a state of emergency was the political crisis over who was the authentic governor in view of the purported impeachment of Governor Ayo Fayose by the State Assembly. It is clear now that the state of emergency was totally unwarranted. None of the crime and insecurity elements required by the 1999 Constitution for a state of emergency to be declared was in place. If anything, the state of emergency proclaimed in the state unnecessarily heated up the polity. In Plateau State, however, ethno-religious conflict in 3 communities, Yelwa, Shandam, Wase, and Langtang, had resulted in the loss of many lives and the destruction of property worth billions of naira. It was not in doubt that the situation had gone beyond the capacity of the law enforcement agents in those communities. Extraordinary measures were certainly required to restore calm to the affected communities. The state of emergency proclaimed in the state by the president and the subsequent deployment of troops to those communities went a long way in bringing about an end to the crisis and restoring calm to the troubled communities. In assessing the impact of the emergency measures adopted in Plateau State, it is inevitable that we try to establish if it has succeeded in restoring peace and security to the state. It would appear that not much good has come out of it, as Plateau State remains a troubled part of Nigeria. Now, the conclusion to that effect is that, yes, there was need for proclamation of state of emergency in Plateau, but there was no need for Ekiti. I believe that we should have that at the back of our mind. How Obasanjo came about, the justification for the proclamation of Ekiti State based on the provisions of Section 305 of the Constitution is one that continues to puzzle any serious student of constitutional law. Well, utilization of emergency powers under President Goodluck Jonathan from 2011 to date. With the intensification of the deleterious activities of disruptive forces in the northern parts of the country since 2011, coinciding with the commencement of the tenure of Dr. Goodluck Jonathan as the democratically elected president of Nigeria, we have been forced as a nation to seriously contemplate ways and means of bringing about a lasting solution to the seemingly intractable problem of crime and insecurity in the country. After a year of a seeming avalanche of terrorist attacks, after a year of seeming avalanche of terrorist attacks in the country, President Goodluck Jonathan acted decisively on the 31st of December 2001 by proclaiming a state of emergency in 11 local government areas spread across the 4 states of Federation, Borno, Yobe, Plateau, and Niger states, on the basis of his power under the 1999 Constitution. The measure was striking in many respects. First, it was a partial state of emergency in those states, the first of its kind in the history of the country. Second, it was the first time in the history of the country in which a state of emergency was declared and democratic institutions were not suspended. And thirdly, no one was in doubt of the desirability of the measure. The argument that has been raised is that the measure was too long in coming and did not cover all the volatile areas in the country. The effect of the emergency measure was that a lot of soldiers were stationed in affected communities, and relevant regulations were passed by the National Assembly empowering security forces to operate in those areas. The president tasked the service chiefs to set up special forces within the armed forces to take charge of restoring calm to the troubled communities, and also assumed counter-terrorism responsibilities. Following review of the situation in 15 local government areas, the state of emergency in some of the states terminated on the 19th of July, 2012. On Tuesday, the 14th of May, 2013, for only the second time in his administration, the president also proclaimed state of emergency in Borno, Adamawa, and Yobe states. The proclamation followed a series of deadly attacks by Islamic militant groups named Boko Haram. In a pre-recorded broadcast, President Jonathan said, "What we are facing is not just militancy or criminality, but a rebellion, an insurgency by terrorist group, which pose a very serious threat to national unity and territorial integrity." The president vowed, "We will hunt them down, we will fish them out, and we will bring them to justice." The president directed the Chief of Defense Staff to immediately deploy more troops to the affected areas. Till date, the emergency measure continues to be in place in the affected states by virtue of the extension of emergency, which the president sought for and the National Assembly approved. Well, we also tried to look at the implications of proclamation of state of emergency from 2011 for human rights and constitutionalism, again trying to pigeonhole that under the mandate and the thematic areas of the Nathanson Center. Under the regime of emergency proclaimed in northern parts of the country at various times since 2011 by President Jonathan, human rights have been brought on trial on account of allegations of high-handed approach the military has adopted in the fight against terrorism. The citizens of the affected states are alleged to endure many violations of their human rights by security forces. A statement released by Amnesty International on the 22nd of May 2013 raised fears about the extent of human rights violation by security forces in the course of their offensive against Boko Haram. According to the statement, I quote, "Several people have been reportedly killed and hundreds arrested since a state of emergency was declared in the northern states of Adamawa, Borno, and Yobe on 14th of May. The military reportedly claimed those targets are suspected members of Boko Haram. Some 2,400 people have fled the region for neighboring Niger, according to a statement released by the International Committee of the Red Cross. Issues of national security and state of emergency do not give the military carte blanche to do whatever they want. The onus is on the state to prove that they are not using an emergency as justification to run roughshod over people's human rights. Over the past 3 years, Amnesty International documented grave human rights violations committed by security forces in their response to Boko Haram, including extrajudicial executions, enforced disappearances, indiscriminate touching of civilian houses, and arbitrary detention. In recent weeks, residents of Borno State in Nigeria have told Amnesty International that mass arrests in the capital, Maiduguri, have increased. Detainees continue to be denied access to lawyers, to their families, and are not being charged with any crimes or brought before a court. Many people have spent more than a year in military detention without being tried or even charged with any crimes. Others have simply disappeared. Individuals in military vehicles have been depositing bodies on an almost daily basis at mortuaries in the town. The government does not appear to carry out any investigation into these deaths and has not released any information pertaining to those deceased and deposited at the mortuaries. The specter of abuse and human rights violation by security forces is exacerbated by the fact that the security forces are fighting an unknown enemy. Consequently, every resident of the affected states in the north is a suspect and can be arrested or killed at the slightest provocation to security forces. This situation has caused many to question the merit of the state of emergency, given the fact that innocent citizens now face attacks from two sides, the government and Boko Haram members. What the military appears to lack is the rule of engagement, guiding their operations to ensure that in the course of fighting Boko Haram terrorist group, they do not trample unnecessarily on the human rights and liberties of the civilian population. Some scholars have argued that the military are out of their depths as they've been saddled with responsibility of both fighting insurgency and carrying out law enforcement. While their training and discipline has prepared them for the former, they have no training for the latter, hence the challenges that have arisen in their operations in the northern states. Nigeria's constitutional development in the area of the utilization of emergency power has been strengthened under the present administration of President Jonathan as a result of the administration's adherence to constitutional principles in the proclamation of state of emergency. Unlike in the past, where a state of emergency results in the unconstitutional suspension of democratic structures, the present administration of Jonathan has been careful not to tamper with existing democratic structures under the guise of safeguarding peace and security in the country. As regards crime and security, especially in the northern part of the country, this remains a big challenge for the government, despite all the emergency measures adopted. Some have argued that the reason for this seeming inability to secure lasting peace in troubled areas of the country is because too much reliance is placed on short-term rather than long-term measures towards achieving peace and security. The effective performance of the police and other intelligence gathering bodies in the country is critical to achieving sustained internal peace. While a state of emergency can be useful in bringing about peace and security when things really get out of hand, it can by no means be regarded as a permanent solution to insecurity in the country. Now, problems affecting exercise of emergency in Nigeria. After about 50 years of the utilization of emergency powers dating back to the 60s, the prospect of a state of emergency being proclaimed by federal government to address security issues, serious security challenges in a troubled country is still regarded with a great deal of unease and suspicion. In this section of the lecture, I will quickly examine the problems with exercise of emergency powers in Nigeria. Much of what will be examined in this session arises from the discussions in previous sections under review. Essentially, the problems that have been bedeviled the exercise of emergency power in Nigeria include, but by no means limited to, lack of protection of human rights, poor conceptualization of the basis for extraordinary measures, institutional fragmentation and poor linkages, the politicization of state of emergency, the problem of internal security and uncertainties about the future. As regards lack of protection of human rights, Lord Walker of Gothenburg warns a potentious but non-specific appeal to the interest of national security can be used as a cloak for arbitrary and oppressive action on the part of government. Whether or not patriotism is the last refuge of the scoundrel, national security can be the last refuge of the tyrant. Under the guise of national security, a lot of human rights violations have been perpetrated during periods of emergency rule in Nigeria. This position has been consistently the case from 1962, when the first emergency power was proclaimed in Western region. I think it remains the situation till date. Again, it has to be borne in mind that the issue of breakdown of law and order that leads to proclamation of state of emergency is one that has not been clearly worked out, and a lot of issues still continue to resonate, challenging the lack of preparedness of law enforcement agencies in the country. The poor conceptualization of the basis for extraordinary measure. A one-dimensional approach has so far characterized the use of extraordinary measures by federal authority in Nigeria. Under this one-dimensional approach, a state of emergency has been given the most restrictive interpretation, which limits it to case of ethno-religious crisis, terrorism, or any form of armed conflict that threatens the peace and security of the country. There is also the issue of institutional fragmentation and poor leakages. Again, this is a problem that the authority in Nigeria must contend with and try as much as possible to address. And then the other issue that I also address is the politicization of state of emergency. As far back as the First Republic, the state of emergency proclaimed by the Tafawa Balewa government was deemed to be politicized. So also, the state of emergency proclaimed under President Obasanjo in 2004 and 2006, respectively. Not much can be said at this point in time about the position that would have influenced the proclamation of state of emergency by President Goodluck Jonathan as it relates to politicization. But even at that, under the administration of President Goodluck Jonathan, there has been greater conformity with provisions of the Constitution in the manner of proclamation of emergency, state of emergency. But there are still those who complain that the president was motivated by political consideration, as he did not go far enough to capture some other troubled parts of the country. The opportunity to diminish the specter of politics in the use of emergency power was lost when the president failed to declare state of emergency when some states in the country were ravaged by flood in 2012. But again, the argument that flows from this is that the president also lost the point when he failed to also declare state of emergency when the militants were also holding sway in Rivers State and Bayelsa State, respectively. Again, people argue that that would have been an opportunity for President Goodluck Jonathan to demonstrate that being from South-South, that it wasn't an impediment for him not to declare a state of emergency in that area. So he has also not been completely excluded from the argument of politicization of state of emergency if he was in a hurry to proclaim a state of emergency in the northern parts of the country and was not in a position to do so as far as the South-South part of the country is concerned. Then I also looked at the problem of internal security, which I believe is a major problem for Nigeria at this point in time, with the issue of ascendancy of the problem posed by Boko Haram and the fact that instead of abating, the matter seemed to be on the ascendant. So the problem is still very much with Nigeria, and it would appear that proclamation of state of emergency has not been able to withhold out. Well, the issue of uncertainties about our future, we are preparing for election in 2015, and just some few months away from now, Nigeria will be ready for election in 2015. The 2015 election presents an opportunity for Nigeria to decide if they want to retain serving political office holders or have them out of office. There are, however, uncertainties, particularly in those states in the northern parts of the country in which a state of emergency is still very much in force. In the event that the current anti-insurgency initiatives of security forces fail to restore calm to those states before the election, it is certain that the president will be forced to seek an extension of the state of emergency in those states in accordance with the provisions of the 1999 Constitution. The question becomes, what would happen to those states during the 2015 election? Would it result in the elongation of the tenure of current political office holders in those states until such a time when elections can be conducted, or would the approach be to hand over those territories to the military or ex-military officers acting as administrators who reports directly to the president on affairs of the state pending when things are stable enough for elections? So the questions raised are very thorny constitutional issues. The 1999 Constitution does not, however, appear to provide some guidance in this regard. Although Section 180 of the 1999 Constitution limits the tenure of office of governor to 4 years, from the date of oath of office and oath of allegiance, subsection 3 thereof provides that if the federation is at war, in which the territory of Nigeria is physically involved, and the president considers that it is not practicable to hold elections, the National Assembly may by resolution extend the period of 4 years mentioned in subsection 2 of this section from time to time, but no such extension shall exceed a period of 6 months at any one time. Based on this constitutional provision, the president can seek for extension of the period of 4 years in Borno, Yola, and Adamawa states until the security situation is calm enough for fresh elections to be conducted. The challenge before us is that on paper, the 3 states, Borno, Yobe, and Adamawa states, are states that are not supportive of the president. Now, how do you interpret a situation where if the president is conscious of the fact that for election to be conducted in those 3 states will mean that the president will not be able to win election in those 3 states, would it not be in the interest of the president to push for extension of state of emergency to continue in those states so that those states will not form part of parcel of those who will contest election in 2015, and to that extent position the president properly to win election? These are the issues that are agitating the minds of many constitutional scholars at this point in time. And even if the president decides to extend the state of emergency, what will become of governors that have exhausted their 4-year duration? Will they stay in office a day longer than necessary, considering the time they took their oath of office and oath of allegiance? Would it be constitutional right for that to happen? Or will the president be in a situation to appoint some other quote-unquote undemocratic persons to take over the reins of government and possibly do the bidding of the president, as the case may be. These are issues that are likely to confront this country come 2015 and later 2014, and we should not be in a position to run away from that obvious reality. Prospects of emergency powers in Nigeria. From the discussion so far, it can be seen that Nigeria has had a very thorny experience with the exercise of emergency powers beginning from the First Republic. The experience of the past generated a lot of controversies and raised serious doubts about the constitutionality of the use of emergency powers in the country. Notwithstanding this fact, emergency powers remain the very important means for government to act decisively during periods that threaten the life of the nation. Regardless of public misgivings about the manner of its exercise in the past, the power to proclaim a state of emergency over any part of the country where the need arises can be used as a force for good to correct any anomaly, which requires the state to take extraordinary measures to bring about its resolution. One key development which raises our expectations in the country that perhaps we are finally getting it right is the return to strict adherence to constitutional principles in the exercise of emergency powers under the administration of President Goodluck Jonathan. So far, the president has engaged with this power in the most responsible manner, successfully avoiding the vindictive posture of previous administrations. Although suspicion of political motivation still remains, it should be borne in mind that the power to proclaim a state of emergency under the Constitution is a discretionary one, which only the president can decide whether or not to invoke. A tangential development which should also hopefully yield great fruits for the future of the utilization of emergency power in the country is the recent engagement between the Nigerian Institute of Advanced Legal Studies with the hierarchy of the military. Arising from this engagement, NIALS published a handbook on the rules of engagement for the Nigerian military. The handbook draws inspiration from international best practices contained in the laws of wars as well as constitutional principles under the 1999 Constitution as amended, in providing for minimum standards to be observed by the military in the course of operation. The work is intended as a guide and does not supersede the directives to be issued by competent military authorities during military operation. The Handbook of Rules of Engagement for the Military, which is the first of its kind in Africa, was formally presented to the military authorities in a formal ceremony. The expectation is that with the adherence to the principles espoused in it, there will be a massive reduction in the cases of human rights violation by military personnel who are deployed to bring peace to troubled areas. And I quickly make the following recommendations. That one, the courts in Nigeria have to be vigilant to cases of human rights abuses which may arise during periods of states of emergency. Where cases of such abuses are brought before the court, there must be no hesitation in striking the right balance between the exigencies of the period of emergency and the imperative need to safeguard the rights of citizens from being trampled upon. Keeping in mind constitutional and international principles on the extent of derogation of rights that is permissible, the courts are in a position to ensure that human rights of citizens is not duly trampled under the guise of safeguarding national security in an emergency. Again, the posting of police officers should be done in such a way that officers posted to particular areas belong to such areas. This is due to the fact that policing at the community level requires that those in charge of keeping the peace in the community are persons so thoroughly familiar with their community that they can notice any suspicious changes in the routine of members of their community and take action before it becomes too late. This position is stated by the fact that police is still centrally regulated in Nigeria, and Nigeria does not operate the state police at the moment. And until that is done through amendment of the Constitution and devolution of power, I believe that this should be a viable alternative. Also, a lot needs to be done in ridding the regime of emergency powers in Nigeria of the specter of politics. This can happen by granting governors minimal powers under the Constitution to proclaim a state of emergency in any part of their domain where the exigencies of the moment require that extraordinary measures be taken to bring about a return to normalcy. This will be without prejudice to the powers of the president to proclaim a state of emergency over any other part of the country. The current approach where a state governor must seek the approval of the State House of Assembly before asking the president to proclaim a state of emergency over any part of or the whole of a state is simply tedious, inefficient, and rife with a lot of uncertainties. Finally, adherence to constitutional principles in the proclamation of state of emergency is the only way to ensure the future stability of the country. The courts must not hesitate to declare to be unconstitutional any proclamation which purports to supplant democratic structures in the country with any other administrative structure. In this regard, therefore, Section 305 of the Constitution should be carefully reviewed with a view to examining any fault lines which may have emerged since 2004 when the first state of emergency was proclaimed under its regime. Where any witness is noticed, constitutional amendment should be carried out to further strengthen the regime and thereby eliminate any ambiguity in the extant legal framework. Good enough that at this point in time, the constitutional amendment is ongoing and obviously added to the national conference that is also ongoing. A lot can be said on the floor of the National Assembly and in the chambers of the National Conference to this effect, so that when the new amendment is done, it will incorporate some of the recommendations that we've tried to make here. In concluding, I want to thank the organizers of this event for giving me this great opportunity to share my thoughts through this lecture. Thank you all for your kind attention during the lecture, and I'll be obliged to answer questions pertaining to this lecture at the appropriate time. I'm very pleased to be here, and I thank you for your attention. Thank you.
Good afternoon. My name is François Tanguay-Renaud. I'm Associate Dean for Research and Institutional Relations here, as well as the Director of the Jack and May Nathanson on Transnational Human Rights, Crime and Security, which is fortunate to be engaged in a partnership with Professor Azinge and his institution through our leading researcher, Professor Obiora Okafor. So I'll now entertain questions. We have about 20 minutes, I think, for questions. Is that more or less? Okay, and so I would invite you, in order to ask questions, to get hold of a microphone, because this event is being recorded, right? Are there microphones around the room? Or? And this one, but Professor Azinge has a lapel mic, so we can use this one. So any questions?
Comments.
Okay, we have one here.
Thank you very much, sir, for that exposition. My question is twofold. The first one has to do
If I can get your name, please.
My name is Emeka Ichoku. Yes. You mentioned that the courts in Nigeria obviously have a role to play, and it's indeed necessary. Are there instances where courts have actually played a certain role in perhaps declaring some, the unconstitutionality of the declaration? And regarding the Handbook of Rules of Engagement, now, is it within the jurisdiction of civil courts in Nigeria to address violations of the military, regarding their execution of, the rules of engagement while carrying out their duties under the operation of the declaration in a particular state? Thank you.
Yeah, thank you very much. The first question, the unconstitutionality of declaration, yes, the court can. The court can, indeed. We were very hopeful that in 2007, when Professor Nwabweze went to court to challenge the provisions of the powers of the president to proclaim and suspend democratic institutions, the matter went as far as the brief stage. And the suspension was obviously, the suspension abated and the 6 months duration lapsed, and automatically the democratic institutions were restored. And to that extent, the matter became hypothetical and academic. To that extent, the Supreme Court was not given the opportunity to go further. But again, it may get to a stage where, of course, constitutional law scholars will also understand the whole doctrine of political question, that again, it depends on preliminary objection that may be filed. Some may believe that obviously the matter is not ripe for judicial intervention and hearing, as the case may be. But again, these are all issues that will allow the court. But in the First Republic, yes, they did, to a very large extent, and they spoke loudly. So as far as the courts in Nigeria are concerned, they've been activist enough in making sure that they do not shy away from their responsibility or abdicate responsibility, as the case may be. Now, the second question of rules of engagement and the civil court, yes. When it is military come military, so to speak, then the issue of martial courts may come in. But once civilians are involved, certainly the civil courts and the civil authorities in the country will have every right. And I believe that at a point in time, even going beyond the immediate past, Chief of Staff of the Nigerian Armed Forces was almost being threatened of being taken before the ICC, International Criminal Court. I believe that they had to work out a way of trying to persuade the people that were threatening from the north to stay action as far as the matter is concerned. And if the matter can go as far as the ICC, certainly it means that the jurisdiction of the courts in Nigeria is not one that anybody can wish away. So when such matters come before the courts, I believe that they will entertain it, especially when it has to do with the violation of rules of engagement as it affects civilian authorities.
Thank you, Professor. Thank you, Professor Azinge. Welcome to Toronto. I was one of your students at the University of Benin back in the late 80s. I am a lawyer. I enjoyed your lecture quite a great deal. You did talk about the safeguards, against abuse, constitutional safeguards, given that the Senate and the House of Representatives are mandated to give approval. Now, one teething question that always crops up relates to when this declaration takes effect. You talked about the publication in a gazette and also the requirement for legislative approval. Now, when we talk about things taking effect in Nigeria, given the enormous powers that the president wields, sometimes people get confused. Is it after the president goes and makes a proclamation prior to the legislative arm giving approval, or is it after the approval has been given? I'm talking about when it is actually implemented. And then secondly, you hypothesized about this ugly scenario that might evolve in the event that the president decides, after looking on the paper outlook and seeing that perhaps those who are the main populace in Yobe, Adamawa and Borno are not those that might likely support him, and he says, well, I'm going to elongate this state of emergency. If we had that constitutional safeguards, given the current state of affairs at the National Assembly, where it's almost half and half in terms of what number of legislators you have from the APC vis-a-vis the number of legislators from the PDP, if we had that constitutional safeguard, do you think this scenario could evolve? Because they could, given that two-thirds could never be achieved, two-thirds majority of the Senate and the House could never support such a politicized approach. Do you think that fear would or could materialize? Thank you.
Thank you very much. Well, when does it take effect? As far as I'm concerned, it takes effect when the Senate and the House of the House of Representatives jointly pass their resolution in support, at least two-thirds members. That obviously is when ideally one should say that it takes effect. But I understand your fear. Your fear is that once a proclamation is made by the president, it will be difficult to retract on that as far as the Nigerian environment is concerned. Well, luckily, like you all know, the party of Mr. President is in the majority. notwithstanding all arguments to the contrary. And I wish to I wish to make the point that those who are claiming to belong to another party are standing on one leg, because patiently the court is waiting to declare their seats vacant if they clearly indicate that they've cross-carpeted or they've defected, as the case may be. So to that extent, we believe in principle that the composition of the National Assembly is still exactly the way it was even before APC came into force. Don't say this because I'm an official of government, but because I know that that is the correct position. And the courts have made their position very clear that once the matter is brought before them, any person claimed to have defected will obviously be in a position to lose his or her seat. But having said that, I believe that the hypothesis is something that seems to be agitating our minds a lot, and we don't know exactly what will happen. But we've presented the scenario. Should Mr. President go ahead to do this for this reason or that reason, what will happen? We want to believe that somewhere along the line, peace will be allowed to reign in some of these states, Yobe, Adamawa, and Borno, and that to a large extent, maybe only the local governments affected will be excised from electoral contestation, and the other parts of the state will now participate. I believe that that is the only way there can be integrity in the electoral process as far as the presidential election is concerned. But more significantly, I believe that the government of the day is working diligently and assiduously to ensure that we at least reduce the menace of the insurgents or the Boko Haram terrorists to a minimum extent before 2015 election. So, but as far as the situation is concerned, I believe that if there's any matter that goes before the National Assembly tomorrow on this issue, the National Assembly will support Mr. President.
Thank you. Thank you, Professor Azinge. I do have a question on the issue of the declaration of a state of emergency in the fight against Boko Haram. It seems to me that, and you correct me here if I'm wrong, but it seems to me that there is a perception that in order for the security forces to fight Boko Haram and fight effectively in the north, then a state of emergency has to be declared. I am wondering, one, is there a provision in the Constitution that limits, for instance, police action or the use of the military or the use of special forces in Nigeria to fight an insurgency without declaring a state of emergency? Or is it necessarily a condition of the deployment of the military in Nigeria, in the internal affairs of Nigeria or any part thereof, that first of all you have to have a state of emergency? Because if I'm correct in my belief that any state, whether Nigeria or any other country threatened by insurgency, can deploy its security forces, including the military, to fight such insurgency without necessarily declaring a state of emergency. It seems to me that then the declaration of a state of emergency or the pretext of fighting Boko Haram and declaring a state of emergency may not necessarily be required in order to effectively fight the insurgency.
Well, for the military to be deployed, it means that we've exhausted the intervention of other law enforcement agencies like the police or special task force, as the case may be. And when that seems to be the situation and you have exhausted all the other enforcement agencies and you now feel that there is need to deploy the military, it is not imperative that you must declare a state of emergency to deploy. No. If you follow the situation in Nigeria, you should bear in mind that in Zakibiam, military was deployed, and in OD, in Port Harcourt, military also deployed, but no state of emergency. But we are now faced with a situation where the peace and security of the nation is so threatened that extraordinary measures, as we've rightly pointed out, is needed. And the extraordinary measures means that we have to obviously deploy the military, and also the president and commander-in-chief of the armed forces must also be in a situation to take control as commander-in-chief. And to that extent, the chief executive, properly or improperly so called, the governor, will no longer be the chief security officer at that point in time. Because once the president takes over as the president and commander-in-chief of the armed forces, when there's a state of emergency, automatically he now directs the armed forces and takes over the powers from the governor. I believe that is the situation now as far as Boko Haram is concerned in the affected states. And for me, that is the right approach, because in some instances, the governors are not in a position to direct the commanding heights of the military, maybe the chief of army staff and the chief of defense staff, amongst others. All those ones will rather take directives from the president as the commander-in-chief. So that's the position. And again, the issue of imposition of curfew, who can do that? It is only the military that can conveniently state that from the situation on the ground, factually and otherwise, that it is important for us to clamp down on the insurgent. Let us impose a state of a curfew for a period of time so that there will be no movement, for them to localize the insurgents and be able to attack them as the case may be. Mark you, the Boko Haram, they are not a standing army. They are insurgents. They are like guerrilla warfare militia. So they just spring up automatically. You need extraordinary measures in order to contain it. So that's why the fear is that more often than not, you find that they are within military and civilian environment. And in the process of trying to attack them, you attack the civilian. So it's a special case that requires special handling. And I don't think that it is something that other law enforcement agencies like the police or the rest can handle. They have clearly overwhelmed the police force and all the other special task force. Indeed, the governor of Borno State recently stated that the Boko Haram sects are better equipped than Nigerian military. If a governor, a serving governor can say that, then you can imagine that it's no longer a child's play for the police when it is assumed that they are better equipped than even the Nigerian military. So the situation is serious and obviously requires serious attention from the military and under the control of the president.
Okay. Professor Azinge, thank you for what so far has turned to be a feast for the mind. One question is this. From your very profound lecture, one could discern that there has been some textual or constitutional improvements from the First Republic down to now the Fifth Republic in terms of the constitutional provisions to minimize abuse of the powers of emergency. But it will appear that there has been no concomitant improvement, at least from my own point of view, in the temperament of those who are the political actors. So the same kind of skullduggery and shenanigan that the First Republic politicians exhibited is obvious now. So what is your take on that? And is there anything that NIAS as an institute can do to improve the lack of democratic temperament amongst political actors in Nigeria?
Well, bad as it may be, I believe that we're deepening democracy in Nigeria, and we are making a serious attempt to ensure that we stabilize democracy to a large extent. If we had continued from 1961 up till date, 50 years of entrenchment of democracy in our constitutional history, I believe that it would have been a better exercise after 50 years. But we only experimented for 4 years, and that was it. 79, we tried 3 years, and that was it. And we never took off again until 1999. As people will always say in Nigeria, we need to deepen democracy by allowing democracy to flourish for a very long time. I believe we will get it right, and we're almost getting there. The temperaments are there, the contestations are obvious, and now people are getting to accept that dialogue and debate is the only way forward, and you can contend and contest and argue and dialogue and what have you, but you don't need to fight over it. I believe that is a culture that seems to be taking place in the country. And secondly, and more importantly too, is the fact that the military seem to have accepted their position. I believe that is the most critical and most strategic thing we have achieved in the country, that no matter the situation, the military seem to have accepted their place constitutionally is in the barracks, and obviously at the whims and caprices of the commander-in-chief. If not, I believe that we have gone through some processes that one would have wondered if hitherto would the military not have come in to take over again. So for us to have stabilized the country in such a way that they've noticed that their place is not in government but in the barracks is a major milestone achievement, and we must applaud that. Well, whether NIALS can do anything in that regard is to continue to engage, and to continue with the conversation, to continue to make sure that we build capacity, especially with members of the National Assembly and state assemblies, to make them come to terms with the realization that they have a fundamental role to play in building up democracy in the country and sustaining it at the same time. And if we're able to achieve that, I believe that we would have played our part.
Thank you, Mr. Professor Azinge. My name is Patricia Williams. I have a number of questions, but it will take me giving a lecture to ask those questions. Because as you speak and answer questions, it raises your rejoinders raising other questions in my mind. Now, if you talk about the emergency in the First Republic, why was it that it took place in the Western region rather than in other parts of the country? You tried to answer that question, but it's a question. Answer that it's still lingering and begging other explanation. Now I'm going to move rapidly from the First Republic to the Second Republic, whereby we had Shagari government, and the Nathanson menace was happening in Kano. You didn't touch upon that. No state of emergency was declared. However, Nathanson was dealt with decisively under Shagari. Now, how do you parley that action in the Second Republic? Soon after the takeover, the return of the Second Republic, and now you're talking about democracy just taking its roots. And I begin to look at the various, I wanted to use a particular word, but I'm going to review it and say the people who are emerging as politicians. You will see that majority of them are military men who had been able to make money during the military interregnum, and therefore can buy their way, or at least facilitate, if I can use a more kinder word, their way into politics. Now you are seeing that as stability. I'm not seeing that as stability. I'm seeing them, the military, as entrenching themselves into power, whereby the civil society had not been able to get in there because they don't have the finances to get in there. Now, so that's why I say I have so many things to talk about. I don't know how to get in. Then the emergency now being declared by Jonathan, and you see it as him towing the line of the Constitution, in that he went through XYZ and then gazetted and this, that. But has each term the ravages of Boko Haram? Now, you talk about election 2015, and you really wonder if those two states would be, if it be to the benefit of the PDP to allow election to hold there. So if we're talking about democracy, 6 months, therefore, they should be out unpacking, especially as you have a military that is conceding to the handbook of intervention. So I think we still have some talking among ourselves to do. First of all, why should we have the state of, why would some terrorists be holding the whole country into ransom? You need to ask that question and ask why. Why are they having the sway? You said they have better military than your Nigerian military government. Isn't that? You talked about the police being in the local government, and yet they are nationalized, yet you want the police to come into their local area in order for them to be able to know. But how will they know? Because they have not worked in that area, because they've been all over elsewhere. So we have a lot to talk about, and I think it's only more prayers for the country. Thank you.
Yeah. Well, let me say that, firstly, the issue of Matasine did not form a core part of this paper. Reference was made to Matasine at the footnote because I was not discussing ethno-religious or internal conflicts in Nigeria. If that was the case, maybe we would have dwelt on Matasine. Maybe we would have dwelt more on Zaki Biam and OD. Like I said, we deployed military forces, but in some instances, in the case of OD, the whole village was obviously decimated completely under Obasanjo's regime. But again, no state of emergency, so I didn't obviously dwell on that. Now, so military men in government. Well, I don't see anything wrong in military men in government, honestly. I believe that to a very large extent, it has been in our interest that some of them obviously flirted with the whole idea of serving in a military administration. And they have helped to stabilize the polity to a large extent. And anybody will tell you that somebody like the Senate President, David Mark, but for the fact that he had the military background and every other thing, he would not have been able to maneuver the Senate successfully the way he has done so far. So I don't think that, and there's nothing in the Constitution that bars somebody who has been in military before from serving in a constitutional democracy. I don't think there's any. The question that is quite instructive is the issue of why Western region. Well, I don't know, but with the greatest respect to the people from the West here, you know, and we must give credit. Generally, the Yorubas are perceived to be the most enlightened people in Nigeria. It's arguable, but that is the position in terms of enlightenment, in terms of education, in terms of exposure, also in terms of radicalism. I believe that is a cultural part of them. So when there is this contestation as far as who is the leader, is Awolowo better than Akintola or Adegbenro, as the case may be, then there is an issue. Zeke's position in the east was clear. Okpara and the rest of them took their position behind Zeke. In the north, Ahmadu Bello was the unquestionable leader. Even at his behest, he offered to have Tafawa Balewa become the prime minister because he never wanted to leave the northern region. So the position was well streamlined in the east and in the west, but they were in the north. But in the west, most people were not prepared to accept the leadership, quote and unquote, of Awolowo. So Akintola was in a position to challenge Awolowo, and Adegbenro was also prepared, and Major Kudumi, who was a minister under Tafawa Balewa's government and was made the administrator, was in a position to take the reins of government and run away with it. So based on that, the West became ungovernable. And then you now know that at that point in time, they used to talk about the Wild Wild West. And it was truly the Wild Wild West because they will burn down anything, they will do any other thing to make sure that they make their points known. So that was why. So it wasn't a matter of politicization of anything. No, it was just a clear cut of the culture of a people, the issue of people acting with impunity. I believe that things would have changed by now. I believe the Yorubas are behaving better now, and the whole idea of the Wild Wild West seemed to have disappeared. Now, the emergency and Boko Haram. Well, like we all know, and in the last television interview the president had before I left Nigeria, he made it abundantly clear when the governor, he said, can I remove the military for few days, so that we now know how you can live comfortably in Makurdi, in Maiduguri. Many people took on the president, but for us it was a clear statement that, look, you are still in Maiduguri because of the military that are there. If not, the Boko Haram people will overrun you. In one night, they will overrun you. So we need the state of emergency for us to sleep well, even in Abuja, and to make sure that they don't just overrun Borno, Yobe, or Adamawa. They don't even overrun the whole of the northern country. So the whole essence of the emergency rule is working out well. But the position is that greater intelligence seems to suggest that these are not Nigerians. Boko Haram are not Nigerians. We have not been able to monitor and control our border effectively. These people come in from Niger, from Cameroon, and they have their links with Al-Qaeda. They'll just come in, commit their havocs, and they go. So we're not fighting Nigerians. So it's deeper than people will imagine. But when you get closer to the security operatives in Nigeria and you get to know the true story, you know that it is something that is more deep-seated than we're seeing. So without the state of emergency, I believe that much more would have happened to the parts of the country that are now under civilian control. I don't think that we are used to throwing everything to prayer. In as much as I am also a confirmed Catholic, but I believe that this is the political will of the people that will solve this problem. God will help us one way or the other, but we need a political will to do so. So we should not just let this, because Nigerians are fond of leaving everything to God, this time around, I believe that it requires more than God for us to get out of this mess.
On this hopeful note, I know that there are other questions. Unfortunately, I am told that we have run out of time. What I would like to take some time to do, though, is to thank warmly Professor Azinge for having come to visit us here at Osgoode. And you guys, of our appreciation, a little token. We are very grateful for both your friendship and collaboration. Thank you. And the topic of emergency is one that's pretty dear to my heart, because some years ago I wrote a PhD dissertation in Oxford on that very topic. And what warms me in the theme and the argument that Professor Azinge has presented to us today is that, it's true that we sometimes need to create space in our constitutional structures and the rule of law to address important problems that could not be addressed otherwise. And that when we create flexibility, where there's a danger of abuse. And in Africa and South America here, in fact, across the world, some regimes have used that label of emergency to basically institute military rules that has lasted for decades. Well, it seems to me that what's happening in Nigeria, it's far from going down that road, given the vibrancy of the debate that Professor Azinge has brought up to us here, and the response from the crowd today. And the engagement with these issues. So we hope that God will be with you and that your people will remain enlightened. So thank you very much.